estate planning mistake number 10. Once I set up my living trust, I'm done. Well, fortunately, that's not the case. Hopefully, you will live for many, many years after you set up your living trust. But what am I referring to here in the context of estate planning? Stuff happens after you set it up. That trust that may sit over there on the shelf collecting dust or in the desk drawer may not be the right fit for you and your beneficiaries when the time comes. Changes happen in things like your wishes. So, for example, you may change over time whom you want to act as your successor trustee to handle the affairs of your estate, your trust, and to manage them not only for you, but perhaps after you're gone for your beneficiaries as well. And what we find here is choice of trustee often does change over time. The person you may have named might be too old now, moved away, died, maybe proven they're not so good at handling assets as you thought they were, or you have someone else that you did not name as a successor trustee who now has proven that they're mature enough and wise enough to act in that capacity. Or you might want to now appoint what are called co-trustees, more than one acting together as a check and balance on each other. Changes in the trustee happen frequently over time. Then, of course, there are also changes in your wishes. Whom's going to get what and when? Not only particular assets that beneficiaries may get, but when's the most appropriate time for them to receive it? Should they receive it all at once? Should they get it over a period of years or as they reach certain ages or maybe meet certain types of achievements, such as a college degree or a graduate degree? These things change as the circumstances and the needs of the beneficiaries change over time. And then, of course, there are changes in the law. Please don't shoot me, I'm only the messenger. Laws do change over time, as well as planning technology. We've seen this at our law firm of Kavesh Minor and Otis, where we have pioneered a number of technical advances in living trust planning over the years. Our personal asset trust to enhance the protection of inherited assets for your beneficiaries from lawsuits and creditors and spouses in a divorce, loss of government benefits and second estate tax. Our IRA inheritance trust, a protective vehicle specially made for IRAs and qualified retirement plans so that we'll maximize not only the protection of those assets, but the stretch out of the income tax benefits. All of these types of things change over time. We know this. We've handled over 2,000 estates and trusts after people have died. And the biggest killer of estate plans, the biggest mistake, is not periodically reviewing it and keeping it up to date. You want it not to be obsolete when the time comes, but in concert with your wishes and desires and the laws. That's why one of the unique services that we give to you as a client of Kavesh Minor and Otis is a free attorney meeting, a free review of your trust plan every 3 years. That's the kind of service that you deserve and you should demand from your estate planners. You see, experience and expertise do count.